I took a business law environmental class in undergrad that piqued my interest in how can I use my career to help the environment. And so I went to law school seeking an environmental certificate program.
Excellent. Excellent. So for those of you just joining us at Touchstone Talks, we have Deborah Piccato here from Carmody Law. She is an environmental attorney, and we're going to be talking a little bit about some changes that are happening in the state of Connecticut. Big change though, right? Like this was a huge process to undertake. I remember when we were trying to understand the Transfer Act. And so now that it's sunsetting, now we're all trying to understand why it's sunsetting and give us some background on why that even came to be, because I knew you were heavily involved in the process.
Yeah, well, first, thank you so much for having me on today. And yes, we are at the precipice of a major shift for the state of Connecticut. It's an exciting time for practitioners. And sure, by way of background, this has been a very long time coming. The Transfer Act is a very unique law to the state of Connecticut. We're only one of 2 states in the United States that has a program like this. And it was passed in 1985, so it's been around for almost 40 years. But over the course of implementing it in the state, unfortunately, what we've seen is that it hasn't been altogether very successful. It was aimed at getting sites cleaned up, slated for redevelopment here in Connecticut, and it just hasn't accomplished the goal. We have thousands of sites currently in the program that have yet to achieve the requirements and close out under the Transfer Act. And overall, the feedback has been it's disincentivized development here in Connecticut and just been a hindrance on the economy. And so several years ago, the state passed legislation setting a sunset date for the Transfer Act and establishing the framework for a brand new regulatory program to take its place, and that's called the Release-Based Cleanup Program. So yes, it's definitely been a long time coming. The law passed in 2020. After it passed, there was a multi-year effort with the state and stakeholders in developing what this new program was going to look like. A working group was formed that included voices from environmental consultants, environmental attorneys, different state agencies, banks, a person from or people from various sectors of the regulated community in Connecticut to inform the process. And so that working group convened monthly, informing Connecticut Deep on different topics in different areas for the program. And that ultimately resulted in draft regulations being issued about 2 years ago initially. And then it went through the very onerous regulatory adoption process here in Connecticut, another very esoteric process. And the regulations, they're about 300 pages, and they were officially adopted this past May with an effective date of March 1 in just a few short weeks.
Right. Probably about the same time this will air, actually.
Perfect.
So the timing is fabulous. Yeah. But so it's interesting, right? So everybody comes to learn about things from whatever direction and vantage point they bring. And from my vantage point, right, we deal with the Transfer Act only in the sale or purchase of a business.
Correct. Yeah.
And so it's sometimes I had this epiphany moment where I'm like, I actually forgot that the point of the environmental regulations were not to, influence the exit of the business, but were actually shaped to create a better environment for the state of Connecticut.
Right. Absolutely. And yeah, so under this Transfer Act framework, it implicated not only conveyances of real estate, but yes, business transactions and asset sales. And it would kind of bring in properties where these businesses have operated. And it became just a huge consideration in transactions and setting up business deals. And how do we work around the Transfer Act and how do we structure these deals? And yes, it was just a major consideration that will no longer have to come into play and will no longer be a consideration for when you're, putting these deals together. That said, I think it's going to still impact business transactions in the diligence phase. So it's going to kind of fundamentally alter just when these questions arise or how these questions arise, it's still going to be a factor for, purchasers of businesses that have sensitive operations that could have impacted the property. And at the end of the day, those buyers are going to want to understand that risk and liability under this new framework instead.
Yeah.
But yeah, that very detailed legal analysis that transactional environmental attorneys have done for the past 40 years will unfortunately no longer be required.
I mean, that's good and bad, right?
Yes.
Everything is good and bad. I'm quite
Exactly.
sure that understanding the 300 pages that are in place as of March 1st will take a good deal of your time as well.
Yes, absolutely.
So if I'm a business owner and I'm going, okay, well, this is great. Now I don't have to worry about environmental issues when I go to
yes.
exit. But what is, like, we're not just going to ignore them because that would defeat the entire, aha moment of what the goal is for environmental regulation. So how does it impact them now?
Yeah.
Or, well, March 1st.
March 1st, right. Yes. I think there is a big misnomer amongst people not in the weeds on this that, yes, we won't have to worry about environmental come March 1. We'll have some freedom here. And that's not essentially what's happening, right? It is just a shift in how and when the state requires parties to be addressing issues. So under the Transfer Act, at the time of the business transaction, under a triggering circumstance, a party, either the seller or the buyer, would have to commit to investigating that property and then remediating any issues that are found. And it's important to understand that for those sites in Connecticut where those businesses have had prior transactions and are already in the Transfer Act, those sites will remain in the Transfer Act. So those obligations,
That's important.
Yeah, they do not go away.
So it doesn't disappear.
Right.
It just
Yes, exactly.
has a different name.
That's why it's been classified as sunsetting and retiring. So the law itself remains on the books. It remains in place for those sites that are already in it.
Okay.
That said, the state is creating an opportunity to what they call bridge over to the new program. So there is that option down the line if it becomes potentially useful to do, but it's not mandatory. And any owners of sites with these sensitive business operations that have been acquired, they're already in the program. We'll need to complete those obligations. That said, for new transactions, any new business transaction, again, will not have to undergo this analysis of is the Transfer Act applicable, but instead there should be an understanding that if you're acquiring a business that has target assets, real property that has been the potential subject of hazardous substance releases, that any owner of that property has liability under this new program. That liability doesn't arise until those issues are discovered. That's a term of legal import and has defined concept within this new program.
Yeah, see, discovered by who, right? Like that's the ultimate,
Yes.
Does that mean I walk in and I go, oh, there's something leaking on my floor, it's discovered? Or is it more formal than that?
So the responsible entities or persons under this new program are going to fall into two buckets. Anyone that's created the issue, and then anyone that's characterized as maintaining the issue. It's maintaining the condition.
Like continuing it, like perpetuating it?
So a maintainer is actually basically the site owner.
Okay.
By virtue of owning the property, you're maintaining that condition that has the potential to impact resources of the state. That said, a tenant can also potentially be a maintainer if they have certain long-standing interests. However, they can be exempted from that liability under the program if they check certain boxes, if they report any conditions they find to the site owner, and if they haven't actually created the issue. So there is an out for tenants, and that's going to be an important drafting consideration in business deals.
Yeah, definitely. Because we always advise owners not to hold property in the same entity. So generally they might be leasing from a related entity, but it's still not the same entity.
Right.
Right.
So it's going to be your creators and maintainers that are responsible under this new program, and discovery is when knowledge of the issue is obtained. So there's a few different ways this can happen. To your point, if you're seeing an active spill occur, a barrel of hazardous substance fall over, that is a visible change in circumstances. So that is
Right.
going to be considered what the state calls a contemporaneous spill, so an active spill. And those are actually already subject to certain reporting requirements under a separate release reporting regulation framework, and which is based on the types of substances and the quantities that are spilled. And if those are reportable under those regulations, then the response action and the next steps would be covered under the new program. So those releases are pulled into the new program and all of its requirements for addressing the issue. So that said, the more nuanced question is, what is the discovery of a historical issue, right? These unknowns. And so there's a few different ways those types of issues can be discovered under this new program. One is having analytical laboratory data, and by and large, that's what the state expects.
So the testing.
Exactly. Phase 2 testing.
Yep.
But the state has said they don't want to encourage willful blindness of issues occurring on sites. And if that was the only way to discover an issue, then no one would ever test and no one would ever
know, right?
Exactly. So the state has established this concept called multiple lines of evidence. They've created a somewhat circumscribed guidance document on what this means. But essentially, if in the course of an investigation, a reasonable person with requisite training and experience observes different types of facts that would appear to suggest a release has occurred, then that would be considered discovery. And what can that look like? Odor, staining, knowledge of the prior history in a certain area of the property where you also have the staining.
So it's going to feel very similar to a phase 1.
Exactly.
Okay.
Exactly. And there is an important carve out from discovery that the state put into the program in order to not have essentially many, if not all all properties captured in the program on day one. And this is called the filing cabinet exemption. And under this exemption, any data that exists up until March 1 that's sitting in the filing cabinet alone can't be the basis for discovery. It won't be a trigger.
Okay.
So on day one, if a client has an old report in the cabinet that did testing 5/10 or February 28th, 2026, on day one, they will not be deemed to have discovered that issue, provided it stays in the filing cabinet.
Okay.
Yeah.
Okay. So if I'm a buyer, right, I'm going to want to make sure I do my phase 1 March 2nd.
Yes.
Who holds liability? Is that still negotiable? Right? Like I know that the Transfer Act itself was specific on who had to clean what and who was responsible. Do we have similar guidelines?
So at the end of the day, in the eyes of the state, any person or company or entity that created the historic issue is going to be responsible. That might not always be a fruitful source of getting the issue addressed because those companies and principals
may not even exist anymore.
Exactly. And so the major bucket that the state will look to for responsibility will be the owner of the property. And from a private perspective and, negotiating transactions, sure, that liability, that cost associated with addressing the issues can definitely be negotiated in terms of who's going to address it, just in kind of a private remediation agreement type scenario and setting aside escrow funds. So definitely can be negotiated at the time of the deal. It's going to be an interesting change to the way due diligence occurs because a prospective purchaser coming to the table, looking at a business that has this property that has potential to have had releases in the past, they can do their diligence, and they are not the creator of the issue if they find it, and they're not the maintainer. They're just
they don't even own it yet.
Exactly. So, in our contracts, and many states do this already, it's going to be important to say, don't disclose those conditions to the owner so that he or that owner isn't then considered to have discovered that issue. So it will have a potential inhibiting effect on kind of transparent discussions on how do we negotiate through this, and if we find an issue, like how will we adjust the purchase price. So that'll be an interesting development.
I see me going la 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 with my fingers in my ears a lot to try to not hear.
Exactly. And that is how these these matters proceed in other states, and the state has recognized that, discovery by a unrelated third party prospective purchaser is not going to be discovery unless and until it's disclosed to the owner. So that said,
if they discovered it as a buyer before they owned it and then became the owner, though, they now own the problem.
Correct. And on the date of that closing, they are officially the maintainer, and that would be the date of their discovery.
Okay.
Yes, if they've discovered that. So yes, a buyer stepping in to look at the property would need to consider what that looks like, the cost. It would need to understand, what is it going to look like to get through this program, address this issue, and then make that business decision. Is this something I want to
mess with or not?
Exactly. Yeah.
I mean, I guess it's not that different than what the conversations. It's just we won't have access to the report to see whether we agree with them or not.
Right. And then if a buyer walks, because there's the inability to have those conversations, or because they deem the risk too high, then you do have a situation where the current owner kind of scratches their head and says, something's going on here. It's going to inhibit future potential buyers. Perhaps it is something I should voluntarily discover and take care of.
Right. If it's a known, how is it going to address historical or runoff, or like I didn't cause it, but
It's
the buyer just discovered that there's a stream of polluted water that runs underneath my building because he did testing.
Yeah. So as part of this new program creation, the state actually did go back and enhance their remedial criteria. And so when I say the regulations are hundreds of pages, I should clarify that 100 or so of those pages are actually our remediation criteria that have been moved into a different book, essentially.
Okay.
So within that portion, there have been enhancements that the state has implemented, one of which relates directly to what you've identified, this migration issue. And there is very reduced requirements for property owners suffering from, a migrating source affecting their property. So provided there's no imminent hazard on your property, so if you've got polluted groundwater and it involves volatile contaminants, those types of contaminants, think radon in residential, that has the potential to affect indoor air. If you don't have pathways of concern like that, or if it's not affecting your drinking water on your site, then there would be very circumscribed requirements and you would be considered to be in compliance. So the state thought that through and recognized that we need to formalize and make that more robust.
Good. We ended up with an entertaining scenario at one point with the Transfer Act where the concern was a lot, 6 lots over, down a hill. And it seemed a little illogical, right? Because the, water flows down, not up. Like it's not going to crawl its way up the hill to us.
Yeah.
But because it was a concern that was presented that, hey, this is close to you, it required kind of phase 2. And then, so it was extra. And then they came back and, 3 months later, came back and said, oh, no, we were wrong.
Shocking.
I feel like we could have figured that out.
Yeah.
So I'm glad to hear that they put some more kind of logical guide rails on it.
The devil is certainly in the details, and I would foresee similar situations because you ultimately still have to demonstrate that we haven't caused the issue and we don't have any imminent hazards. So at the end of the day, could DEEP still require what some might consider unnecessary testing? Maybe. But yes, there are better guardrails. That's a good term.
Well, and better guardrails will mean the testing people are not tied up with everyone. Right? Because they now have some normalization, I think is a good word.
Absolutely. Yeah. And I'll mention another enhancement that I think is a great development for the state of Connecticut. So Connecticut's a very coastal state.
Right.
We are the subject of a lot of historic filling, legal filling by the Army Corps of Engineers. And, a lot of this fill is contaminated and has fragments and, it's mixed with various materials that ended up, causing
Well, and it's
contamination issues.
historical,
Exactly.
right? So it's
Yeah.
not, nobody was testing 50 years ago, 75 years ago,
Exactly.
any of these things.
Yeah, and it's a significant hurdle at many sites. They have been unable to achieve regulatory closure because it's just a challenge. It's a very heterogeneous issue, so you're not going to have like uniform impacts across the site, and so the sampling alone can be very burdensome, and it's caused a holdup on a lot of different sites. So the state recognized this, and they've developed essentially a long-term institutional excuse me,
No, you're fine.
institutional control mechanism that would allow this fill to stay in place, provided that the property owner kind of follows various guidelines and is checking various regulatory boxes. So it's called a permit by rule, which essentially means as long as you're meeting the requirements and the regulations, you are covered. You don't need to actually seek a permit from the state. You're just considered to legally be permitted if you're following the rules.
Oh, that's good.
Yeah, and it's going to allow a lot of sites to be closed out more efficiently. And yeah, I think that's a great step that Connecticut.
Yeah, that is excellent.
Yeah.
I mean, we are a historic state. People have
Yes.
been living here since 1600s.
Right.
And so that's good that they considered that. There were
Absolutely. Yeah.
that was always a concern, like with because the Transfer Act started, right? But that doesn't mean the people that owned the business prior to that hadn't manufactured something.
Right. Absolutely.
That-
Yep.
And so then you're not going back.
Right.
They're like, who am I going to transfer this to?
Right.
Like,
Absolutely.
so
Yeah.
They aren't here anymore.
Yeah.
So that's a good step, which
Yes.
puts it back in that framework where we started. Was the goal of this is to create an environment with improved metrics. Right?
Absolutely. To get these sites cleaned up and kind of back to use for redevelopment and kind of bring economic developments to the state.
The file cabinet component is one that I think is good, but I also am worried, right? That willful ignorance component falls into that. So if I'm a business owner and I'm sitting here going, well, I was worried about my site because I thought maybe something, I don't have any proof, but I think that maybe the person before me did things that weren't great. So I haven't tested anything. I haven't checked anything. What's a better plan for me? Do I wait and let my buyers test and then have no knowledge? Or if I test now, do I have to clean before I can sell? Like,
yeah, that's a really good question. And I think that can shake out in so many different ways. So there is a benefit to letting a buyer conduct the testing without obtaining knowledge of what they're finding, going into the deal with a recognition that this is as is, you take what you find, you don't disclose it to me. And there may be buyers out there with that risk tolerance and sophistication to do the testing, understand what the requirements are going to be, and close the sale. And the further upside of that is, if they end up walking away, you've got an indication. You don't have that knowledge yet, but you've got an indication that potentially there's an issue here, and you can be strategic in your timing about when you want to address it and kind of do your own investigation and officially discover it and take care of it. So you can be, a little strategic in the timing there. But yeah, I think that's going to be an evolution and just a whole new set of considerations for going forward.
and it's
we're all
a
gonna,
very different way to think about it,
yes,
right?
yes,
Like
it's very different.
So if I'm worried and I may not even know, right? Like, I know how to produce aerospace parts, or I know how to, to produce solder, and I know the chemicals that I'm using, but so where can I go to find out before it's discoverable, right? Like before it counts as a discovery? Is there somebody I can talk to that could go, hey, yeah, you're worried about something that's not even on the list? Because it could happen, right?
Yeah. Yeah.
Or I could not know what the list is and be doing things that I didn't even know.
That's true. So we only have a few short weeks, but there is this very minimal opportunity to, engage with a consultant now to kind of get a baseline understanding of what the risks and issues could be on your site based on historic developments. I do think that once we pass that March 1 commencement date, that anytime a consultant initiates or does an investigation of a site, there is a risk of that discovery. Right. And it's a significant risk. And I think on recent training sessions that Connecticut Deep is convening for the regulated community in the state, I think they've clarified their position that, a consultant doing an investigation, it's going to be very rare that they will have a single line of evidence because odor staining and any knowledge of the site history that kind of indicates, operations that could have resulted in a release, it's going to be an easy trigger is my understanding of how Connecticut Deep is looking at this. So if there's no information existing before March 1, I think careful consideration would have to be done. And full disclosure that engaging a consultant comes with a significant risk that you may get engulfed in this program.
Got it.
But that said, the way the state has set it up is they want to incentivize not needing to report to the state, not needing to get involved with regulatory filings. And so they're, depending on what's found, if a party an owner does decide to do analytical testing, if they find something, there are windows of time in which to potentially address the issue. And if you do that, then you don't need to even report it to the state. And so Connecticut Deep did try to structure it to incentivize getting things done quickly and avoiding administrative red tape and hurdles.
Gotcha. But they're still better off using a ChatGPT scenario.
And would ChatGPT be a reasonable person with requisite experience, training? I think it's going to come down to that's an interesting nuance.
If I put in all the chemicals that I am using into ChatGPT, will it tell me if I need to be regulated?
I feel like that would be an evolving consideration that Deep might add to their guidance. It's becoming so prevalent.
It is.
In terms of
Absolutely.
Its use. Yeah.
Absolutely.
I had not personally thought of it. So very interesting.
Just, I had an owner say to me once, I changed the oil of my car. I'm like, a lot? A little? There's actual metrics here.
Right. I should note there are various exemptions built into this new program and framework, and I would say many of them arose due to a lot of concerns voiced throughout that multi-year development process. So some of them I could just run through.
Yeah.
Originally conceived, this was going to be applicable to every property in the state, including residential. And
oh my goodness.
Yeah. So, but in response to a lot of concern about that, the state did include basically an exemption for single family residences that as long as you don't have a significant hazard, as long as you're not affecting any neighbors, you're not going to be subject to the program.
You can keep your can of paint.
Exactly. Keep your can of paint. And the theory is you can live in your pigsty, but as long as you're not affecting other people or that there's not significant hazard concern, we're not going to require you to hire an expensive consultant and comply with this program. There's also what the Connecticut DEP calls a lower bound. So there was originally drafted, the program comes into play anytime there's any detection of any measurable constituent of a contaminant. There was concern, what if you've got trace amounts? That's going to be every time you do anything. So they did create a 25% threshold. So if the consultant finds for most contaminants under 25% of the cleanup criterion, that's not going to be subject to the program.
Okay.
Yeah, so that creates a nice little baseline. And then there's what the state calls incidental releases. So they'll think road salt during winter storm events, fire pit that create hydrocarbon issues, that's exempt. It's a recognition that,
people have fire
exactly.
pits. Yes.
Yeah.
Let's say the company picnic happened here.
Exactly. Any discharges or releases to a secondary containment that gets cleaned up within a certain window, that's not going to be subject to the program because it only applies.
So the I changed the oil went into the container got picked up by the service.
Correct.
That's no longer an issue.
That's not going to be considered, right, a
Okay.
release. So the
Good.
program applies to releases to land and waters of the state. So they don't consider secondary containment, land and waters of the state.
That's true.
Again, there's always kind of boxes to check. So
Oh, absolutely.
But yeah.
Absolutely.
yeah, so the application of pesticides or fertilizers, if done so consistent with labeling, that's not going to be subject to the program or considered a release to the environment. Automotive exhaust and atmospheric kind of releases to air. Deep like to use the example of like a tanker carrying gas on the road falls over. That's not going to be considered a release for purposes of this program. It's subject to other
programs.
Yeah, of course.
Yep.
But yeah,
Okay.
so they're
it
built
sounds,
in.
It sounds more logical
Yes.
than what we had in place before. We used to tell our clients, I know they're coming for a phase 1, and they'd be like, we're going to clean up. I'm like, actually don't, because chemical smells could be a trigger.
Right.
Yeah. And we did have someone that painted their electrical box and ended up with a phase 2.
Oh dear. I could see that. Yeah.
It's like, so I'm glad we have some better guardrails.
Yeah,
going
absolutely.
forward.
Yeah, and it is a reasonable program. And honestly, it mirrors what 49 other states here
That's
in
correct.
America do. So the thought at the time, 40 years ago, was, we're being very innovative and different and it's going to be great. But, unfortunately, that didn't pan out. And the thought process is, let's kind of get on the track that most other states are doing. And it's, works well in those contexts. And we think it can work for Connecticut. So
Great.
yeah.
Great. Well, I'm sure there will be nuances that come out. And so if anybody has questions, make sure that your Deborah's information is on the bottom of the screen. If you're on YouTube, it's on your podcast screen. If you are working from a podcast platform, I'm sure she'll be happy to hear from you and offer any guidance that you might need in this. And so thank you so much for coming. I have one more question.
Sure.
So if you were doing any other career, right, besides environmental attorney, looking back on your life, you have all the choices to make again. What would you do instead?
That's a great question. And I've given thought to this. I would love to be a wildlife photographer that, Nat Geo travels the world and takes photographs in beautiful, natural
Penguins and lions and tigers and bears.
Exactly.
Absolutely.
Yeah, I think that appreciation for the environment is always there. So yeah, that would be my alter career.
Great. Well, thank you for sharing. Those of you that are joining us on Touchstone Talks for the first time, please like and subscribe on our platforms. We'd love to have you join us again. And have a great day.
Thank you.